Thank you very much for participating in this panel today, second day of the 60th International Conference on Competition and Innovation from IBCI. And it's a great pleasure to have here two amazing scholars, Mariana Pargendler and Teodora Groza. They're going to have a chat about corporate governance and competition. And I give the word to Teodora. Thank you very much for your effort to be here.
Thank you very much for hosting this and for inviting both of us. So just to give our audience a bit of a background about this chat, I was invited by Eduardo to host it. And he told me that it's meant to be an informal, exciting conversation with any scholar that I find intellectually stimulating. So the first idea that came to my mind was to invite Professor Pargendler, who is a specialist in corporate governance, corporate law, and contract law, and incorporates a lot of law and economics and comparative law approaches in her scholarship. She's currently a professor at FGV Law School in Sao Paulo, but will join the Harvard Law faculty as of July 2024. I met Professor Pargendler back at Harvard about a year ago, and we had a very intellectually fruitful dialogue in her office. So the idea of this fireside chat was in my mind to make that dialogue public, because I think that lots of competition law academics could learn a lot from the ideas we shared back then. So something that bothers me a lot about legal academia is that it tends to be very siloed, in the sense that scholars tend to be stuck in their tiny little pigeonholes and not interact much with people working in other fields of law. And this is also true with competition and corporate lawyers. Sometimes this is even portrayed as a binary choice, as in corporate law is about firms, competition law is about markets. You choose your field and you stay there, you don't look across the fence. Fortunately, in recent years, we have more and more interaction between the two fields of law, and Professor Pargendler and I are just two examples, but there are many fabulous scholars working on this intersection. Nonetheless, something I find a bit problematic about the discourse that this is a new field, a new intersection, is that things are not quite this way. So my first question to Professor Pargendler would be, what used to be historically the relationship between corporate law and antitrust? Did we ever see antitrust concerns plugged into corporate law? And if so, how did that look like?
Well, first of all, good morning. Thanks for the organizers for this invitation. I was so happy to receive a message from Teodora to have a conversation. That meeting that we had last year at Harvard was also so inspiring for me. And so I was very happy to try to reproduce it, although it's very hard to reproduce it, because also part of what inspired such an interesting conversation was your research, Teodora. So maybe towards the end, we can just open some space so you can fill us all in your findings, because you're really pushing for us to think about the contributions or the connections, and perhaps also tensions between competition law and corporate law. So I am primarily a scholar of corporate law and governance. However, where do you draw the line? And in terms of your question, it is the case that in the history of corporate law and corporations, that line was quite blurry. So today's growing, and I think actually now fading, consensus that the objectives of corporate law are quite narrow, were not there yet. So a primary function of early corporate laws was actually to address concerns about competition and market structure. So one of the things that I mentioned in our conversation is that I've conducted research together with Professor Henry Hansman on the governance structure of the earliest corporations. So we did that in the US and also in other countries, including Brazil. At some point in my life, I read a whole lot of corporate charters. And what those corporate charters showed is that voting caps that is, the limitation of the maximum number of votes by shareholders, were quite common among those early corporations, which raises the question, why was that the case? And we posited that we had to be very sensitive to the context of those early corporations, because many of the early corporations were in industries that were natural monopolies on the one hand, and they were also owned by customers or consumers of those firms. So in that context, a very important function of those voting caps was to make sure that those companies would be run for the benefit of consumers and not be appropriated by an investor who would then be able to charge monopoly prices from those very same members. But the functions of the antitrust functions of corporate law did not stop there, of course, and they even helped name the field of antitrust. It's really interesting. The antitrust, it's called antitrust. It's not called anti-corporation. And the reason is that for in the early days, holding companies were unlawful under the early corporation statutes. So consolidation had to take place through different business forms, and the trust was quite helpful in that regard. Now we know that is no longer the case, so now it eventually became lawful for corporations to own shares in other corporations, and I think we'll talk about that too. But those competition functions were quite conspicuous in those early antitrust statutes. So I think I'll stop here, but though we can have a more recent conversation about this topic as well.
Your answer is fantastic because it shows how the relationship between the two fields of law is actually much more organic, and it dates back to at least the 19th century. But the question is, how did this change? What provoked the dissociation of the two areas of law? What caused this division of regulatory labor that we have today? Was it a change in regulatory technique, in law and economics in general, in societal ideas about how society should look like, or all of the above?
Well, it's generally all of the above, right? But I'll begin with a narrower answer, which is the standard answer. The standard answer is actually an answer that relates to the topic of antitrust, which is that the forces of regulatory competition pushed corporate law toward that narrow, more specialized role. So in the US, we started with the theme of antitrust, and that's because you could form a holding company, so you form trust instead. Well, that was on the earlier days, because eventually New Jersey found a market opportunity and thought, well, maybe we can offer holding companies in our statute. And that was a game changer. It is the case that New Jersey later backtracked, but then the recipe of regulatory competition was already open. So Delaware later became the winner of the current competition for corporate charters in the US. So the ability, the existence of regulatory choice, which exists in the US and just to a certain extent also globally, constrains to some extent the use of corporate law for other public policy objectives. So I think that's the standard account. Of course, there are limitations to that account, because regulatory competition only exists where we allow it to exist. So it's always possible to constrain such competition, which I think is a very important area of current debate. So this is one possible answer. Another way to look at this phenomenon of specialization is that it has been the object of a theoretical vision or a scholarly consensus, which goes to the importance of ideas. And one strand which affects both corporate law and antitrust law, as well as other areas of law, is law and economics, and particularly the mainstream version of law and economics that gained prominence and influence in the 1960s and 1970s. And that particular version of law and economics is premised on an idea that I have called modularity, which is the idea that each area of law contributes to efficiency or welfare through functional specialization. And the contribution of corporate law in that regard is the reduction of agency costs. The contribution of antitrust law is through the increase of consumer welfare and so on and so forth. And clearly distribution objectives should be targeted by the module of the tax and transfer system. So beyond some institutional limitations because of regulatory competition, there has been a consensus that that type of specialization is normatively desirable. I actually believe that that consensus is currently in crisis, and therefore there's greater room for the discussion of different public policy objectives through various areas of law. But I think that that modular approach of traditional law and economics has played an important role in creating the silos that you have that you mentioned previously.
So your answer shows us that we started at a point where corporate law was a much more potent tool which could address societal harms which range beyond agency costs to monopoly concerns. And now we are at a point where we have this modular view of regulation where each area takes care of its own issue. But as you said, this approach is in a crisis, and the crisis is not endemic only to corporate law, but we see it also in antitrust. And I think Vinicius can agree with me here that one of the most prominent debates we've had in antitrust for the past decades is what is the goal of the law? And as you said, the orthodox view is that competition law is a consumer welfare enterprise. All we care about is securing low prices, high output, and high quality. But then again, there is a solid strand of scholarship that argues that competition law is actually much more. It's a sort of constitutional law of the market, which could address other types of harms, as in promoting economic democracy, protecting small businesses, and so on and so forth. One issue with this modular approach is that I think that it prevents us from seeing how different regulatory areas could be used jointly to address the same harms, and how they could collaborate in achieving any societal goals that we think the law should strive towards. So in competition law, we have this debate on goals. In corporate law, you said you have a similar debate. Can you tell us a bit about what are the alternatives proposed to focusing only on mitigating agency costs and how they could maybe relate to what we see in antitrust in terms of the reach towards sustainability, protecting small businesses, data protection, and so on? Sorry, I think you are on mute.
I don't know how that happened, but great, great, Teodora. Thank you. And just before proceeding, let me just pause here to just acknowledge that that type of modular separation has always been quite artificial, and I think that precise semester when we met, for whatever reason, I decided to reread Henry Main's very classy seminal work on the market for corporate control, which posits that the best solution to agency problems, which are the primary concern of corporate law, is through a market for corporate control, which is going to be realized through hostile acquisitions. And so that's the story I had in mind. But when I actually opened the article, I noticed that the article was in clear dialogue with antitrust scholarship. So it begins saying, well, antitrust scholarship is being rethought. Things that we thought were malign, now we have benign interpretations. And let me give you a highly benign interpretation for mergers. So even though they are, his interpretation for mergers is in the context of of a highly modular corporate law approach, it still had very important implications for the debate in antitrust law, and that actually I think was a key part of his motivation. I do see some parallel trends in corporate law. So you said that the debate about antitrust law these days is all about purpose. Clearly, the debate about corporate law these days is all about purpose, and that change has been dramatic and quite recent. For me, what really drives this home is that about, I would say maybe 10 years ago, I had the opportunity to join a book called The Anatomy of Corporate Law, which is a comparative corporate law book. And my mission was to update the book since 2009, which was the second edition of the book. And something came to my mind then, which was that so many of the things to be updated were not designed to mitigate agency costs, but had broader objectives. So systemic risk was a big one that was after the financial crisis, but you also had non-financial disclosure, women on boards. And then I had a very interesting conversation with my co-authors, who were all very senior scholars in the field and people I greatly admire, which is that they looked back at me and says, wow, this is all very interesting, but this is not corporate law. So gender quotas is not corporate law. I'm like, but how come it's not corporate law if it determines the people that can sit on boards, which is the primary governance organ of a corporation? Then no, it's not corporate law, because if a given rule has a different objective, it's not corporate law. And that is how strong that consensus was. 10 years later, every single corporate conference right now is about corporate purpose and having a discussion about whether the purpose should remain narrow or should be broader to encompass social issues, governance issues, ESG, and the like. And I understand that something very similar has happened in antitrust law, in which we are not only having no longer only a discussion about the means, is this rule good in view of the consumer welfare end, but people are having a discussion about the very end. That raises a question of what's driving this crisis of modularity, and I'll share my view here on this, which is clearly, and I think that view is very dear to the global South or developing countries, and in some ways, I view the current developments in the global North as converging to the mindset that has ruled the global South for quite so long, which is the realization that maybe other areas of law are not doing their job. So what do you do if you have a climate emergency, but environmental law has not been enough? What do you do if you have soaring levels of inequality and the tax and transfer system has been unable to address it? That, like it or not, that does, and things seem incredibly urgent. Like it or not, that does create pressure on different areas of law to take some of those tasks. So I think it's not so much even an alternative to the modularity approach, but it's even almost a corollary to the modular approach, because the modular approach relies on other areas of law, doing their job. So I think this is where things are. In corporate law itself, I can tell that the financial crisis had a very important role in attacking modular thinking, because clearly after the financial crisis, a consensus emerged that shareholder wealth maximization was not a good idea for banks because of their systemic risk externalities. And I think there was a consensus there. There were no different voices. And for me, even that time, it was very clear, why would you stop at banks? Because banks are not the only types of corporations that have externalities. And I think lo and behold, and also because some issues became increasingly salient and felt more urgent, that type of pressure conquered mainstream corporate law, and I think the same is going on in antitrust law right now.
I love your answer because it shows that the global north can also learn from the global south, and it's not just vice versa. I come from a part of the world which I like to refer to as the global east. It's the former communist bloc, and it's usually perceived as a part of the legal world that's insignificant. It's only relevant as a sort of experimentation site for policies from the West to be copied and pasted. But your answer really showed that our experience in the global south and the global east has informed an alternative approach that the global north is now taking over. Can you give us some concrete examples as to how jurisdictions in the global south have adopted a new corporate governance approach, which goes beyond shareholderism into what you've very nicely called heterodox stakeholderism?
Sure. So I'm completely with you regarding the way that the comparative literature proceeds. And I think there is a huge problem there. So people have called it the rolled series syndrome, in which you draw generalizations about the world based on a handful of usual suspects in the global north. And the problem with that is that we miss opportunities to learn, and even we might sometimes maybe recreate the wheel or attribute originality to features that have been experimented with before or elsewhere. And so I'm really interested now in expanding comparative corporate law and governance to also look at the global south, but also look at the global south with different lenses, because it's not that people have never looked at the global south. They have. There are international organizations that are very interested in benchmarking laws around the world, but the problem is that when people do that, they do that with the questions and metrics that they consider in the global north. And then, oh, surprise, surprise, the global south is a terrible failure. But you don't learn what you don't ask. So in that particular project, I tried to examine heterodox, meaning different manifestations of stakeholderism in the corporate laws in the global south. And that would be heterodox stakeholderism, meaning approaches that on the one hand are different from what is the norm in the global north, or the spectrum of possibilities you see in the global north, and on the other hand that incorporate broader public policy or distribution objectives. And perhaps surprisingly, it was even surprisingly to me, even after setting out to write such a project, how much there is. Moreover, something that was really interesting to me in this project was that I realized there's some form of odd duck syndrome in the literature, because global south jurisdictions are usually not studied in reference to one another, but rather, if they are studied, they're studied through case studies that compares them to the body of knowledge in the global south. So you see, for instance, exceptions to limited liability of parent companies in India, and people would say, wow, India is exceptional, one of a kind. And I would tell them, welcome to Brazil. If you'd like to see exceptions to limited liability, welcome to Brazil, because there's quite a lot here. But not only here, there are examples in Argentina and Colombia. So one question, and perhaps this is my main interpretation of these findings, is that actually corporate laws in the global south are not only failed transplants or even perfectly adequate on the books, but suffering problems of enforcement, but they rather adapt to the local context. So to use one example, limited liability or it's veil piercing. So veil piercing is quite common in Brazil, in the areas of labor law, consumer protection, and environmental law. It's in the letter 2, it's actually even on the books that whenever legal personality is an obstacle to the compensation of environmental harm or harm to consumers, courts may pierce the corporate veil without any need to prove abuse. So, hey, that's consumer protection. That's stakeholder protection for you, though through very different means. We could go one step further. Even our system of regulation of financial institutions relies on the imposition of liability on managers and controlling shareholders of financial institutions for failure. And that was quite deliberate. And their theory was it's so hard to regulate financial institutions. It's harder everywhere. Perhaps it's even harder here. So let's try to compensate for that difficulty with another form of corporate law and a different set of incentives. So this is one example. I mean, another example, which I mentioned gender quotas before, but the comparative corporate law literature loves to talk about the very interesting experiment by Norway to introduce gender quotas in corporate governance, and that eventually became very popular across many jurisdictions, not Brazil yet, but certainly many European jurisdictions. And that is like the rise of diversity in corporate governance. But Malaysia and South Africa, they've had different but quite bold and aggressive mechanisms of affirmative action in corporate law for the Bimutera minority in Malaysia and for Blacks in South Africa before the Norway quotas. And we know that now the issue of racial diversity in corporate governance is reaching the global north in the United States, but that is an area in which the global south has taken the lead and had more experience, perhaps because the problems were even stronger and more salient, and therefore necessitated the type of distinct response.
So you mentioned in your answer that when scholars, usually from the global north, look at the global south, they don't see broader trends, they look at countries in isolation. And you were saying that this leads to exceptionalism, but I would argue that it also leads to a sort of pathologizing gaze, where they see something that goes astray compared to what they are usually seeing in their own jurisdictions, and perceive it as a deviation which is inefficient, dangerous, and should be eradicated as quickly as possible. But then, as you showed in your answer, what's happening now is a reverse, as in the global north is slowly trying to implement changes we've seen happening in the global south for so long, but nobody has actually talked about. Do you see any credit given to the global south when the global north jurisdictions actually implement these changes? Or it's more of reinvent the wheel approach, where they sell what they're doing as being groundbreaking and revolutionary?
I don't see much credit yet, but I hope there is more credit in the future. And I think really a real problem with giving credit is even knowledge, right? So I think certainly for the debate on stakeholderism in corporate law, even though it's an old debate and people know it's an old debate, there are new labels now and everything seems fresh, and there's a lack of knowledge about the experiences in the global south. I completely agree with you with respect to the usual negative connotation associated certainly with exceptionalism and also with particularities in the institutions in the global south. I think the field of comparative constitutional law has important accomplishments in that perspective, I think that they have been able to sufficiently infiltrate the global north mainstream to show, hey, there's something different there that is potentially interesting, potentially promising, certainly worthy of study, and it's law, because that's another problem as well. There is the sense it's quite conventional. It sounds very radical, but it's quite conventional. That whatever the global South has is not quite law. It's law works so poorly that it doesn't even count as law. Well, I mentioned before again the joining the anatomy of corporate law, and actually when I was asked to join, they told me, Mariana, you're going to be updating the U.S. section. We've already made a decision not to include Brazil. And I said, fine. But later I continued pushing for the inclusion of Brazil. And I think in that way I was aided by collective action problems, because they had a strong interest in including Brazil, and they didn't have a strong interest in resisting Brazil. So Brazil prevailed. But in the context of including Brazil, I had to delete one footnote in the book that said that they had focused on developed countries because in developing countries, the law doesn't quite work, so extra legal mechanisms necessarily prevail. And I think, of course, there are enforcement problems in the law in Brazil, in other global South countries, in various global North countries as well. But I think that devaluation of legal experience of not even counting as law is quite problematic. But you had a question, Teodora. I went on a tangent. Can you remind me of where you're going at?
So the endpoint of this discussion about stakeholderism and antitrust was whether in the end antitrust scholars and corporate lawyers could hold hands and try to incorporate together broader goals. As in, if you want sustainability, should we maybe cooperate in terms of how we expand antitrust toolkit, but also how we expand the corporate law toolkit? Do you think such cooperation could be envisageable in the future?
I think potentially, yes. I think the most important, I think modularity is too constraining. And we need to be more open-minded. However, I think after that, we have to have very careful conversations. At a minimum, I think it's really important to think about the boundaries or the effects of a given solution on the other field. So I think that type of conversation is very important. I think you said something slightly more normative. Is should they hold hands toward a greater sustainability? I mean, in theory, they can. I think there's no reason why corporate law and antitrust law should not play a role with respect to sustainability. That sustainability must be delivered exclusively through environmental law. And if corporate law hurts it and antitrust law currently hurts it, we don't care. I don't think that's a reasonable proposition. But I think it's also important to be mindful that certain things that are good for corporate law might be problematic for antitrust law and vice versa. So I think we were discussing the complementarities, and I think there's room for that. One example that I really like is through the work of Ji-Young Min on the antitrust laws of South Korea, and says there are very strong anti-tunneling or anti-extraction of private benefits of control rules in the antitrust law of South Korea. It's interesting that they appear there, but I think the point is that some practices that might be bad from a corporate law perspective and from a competition law perspective. But I think the opposite might apply as well. And I think this is something that we might want to think about. I think one great example these days, and I'm not taking a position on it, but I'm just raising the issue, is the debate about common ownership. And I think so antitrust scholars are worried that very few institutional investors control so many firms in an economy, including firms in the same industry. And almost all corporate law scholars says, no, let me assure you, there is absolutely no problem here. And I'm not trying to assess here who is right, but I think part of the reaction from corporate law scholars is that they think that a certain corporate governance scenario is beneficial from a corporate law perspective, and therefore are less willing to consider spillovers to other areas of law. And I think it's important to be mindful of when they work to reinforce one another, or actually when there might be where there might be some tension about the roles of each field, and whether they might want to accommodate the effects it may have on the other.
Exactly. So far, I tried to steer the discussion towards how antitrust and corporate law can collaborate. And we talked a bit about sustainability as an example. We talked also about how in the past there were cross-fertilizations between the two fields. But now, since you put on the table the issue of tensions between the two fields, I want to move the discussion in that direction. So can you tell us a bit about how corporate law looks at separate entities, and whether you think that the ways in which corporate laws define different legal entities is bulletproof, or whether there would be some room for seeing beyond such boundaries?
Thanks, Teodora, for this question. A lot of beyond the global south strand of my scholarship, I've been thinking a lot as well about what I term corporate separateness, and actually it's really interesting that, because in my own thought process, when thinking about those fields, I had data points from antitrust. So for me, it was always interesting how antitrust treated corporate separateness, which was at the very roots of that project for me. I would rephrase the concept or the discussion not necessarily as a tension between corporate law and antitrust law, but as rooted in the misunderstanding in the literature about corporate separateness, not only with respect to corporate law, but also with respect to antitrust law and other fields. I think antitrust actually has been relatively lucky in being more immune from this understanding than other areas of law. And the misunderstanding, which I'm calling now, is what I've termed a fallacy of complete corporate separateness. Mm-hmm. So let me begin about what is corporate separateness properly understood. It's clear that legal personality creates a new nexus for the imputation of legal rights and duties. And that is the case for a legal person. That is the case for a natural person. That person can have rights and duties in her own name. What is the fallacy? The fallacy is to say, therefore, the legal spheres of different persons, legal persons, that's usually how the debate goes, must be completely insulated for purposes of liability, for purposes of the imputation of legal rights and duties. And that, I think, is a misunderstanding. So the law doesn't operate quite like that. The fact, I always like to use the natural person's example. There's myself, you have my daughters. They're quite separate from me, but the law doesn't always treat them as separate from me. Like for I have various duties owed to them under Brazilian law. I'm liable for their torts. I wouldn't be independent from them if I were to sit on a company who's controlled by them. So I think for various aspects, there is a significant degree of legal interconnection despite separate incorporation. And antitrust law, in a way, was a leader in that entity transparent view, or what I call veil peeking, looking behind the corporate veil and trying to regulate economic phenomena irrespective of legal entity boundaries between shareholders and firms or parent corporations and subsidiaries. And I think it's easier to see that fallacy in antitrust law, but it is also the case in corporate law. So one of my new papers is what I call the new corporate law of corporate groups, which asks the question, well, do shareholder rights pass through to cover subsidiaries? And increasingly, there's a clear trend around the world in corporate law that the answer is yes, they do. because it makes complete sense from an economic perspective. It doesn't matter from the perspective of a shareholder if wrongdoing takes place at the parent level or at the sub level. It will affect the shareholders' pockets either way. So this is an area in which I think there has been a misconception about the implications of separate legal personality, and antitrust has overcome that, I think, with a greater speed and a more natural tendency compared to corporate law, where people think that absolute legal insulation applies, but that doesn't even reflect how corporate law itself operates in practice.
So in the beginning, we talked about how this modular view is slowly being eroded. Now we talk about how corporate separateness is being eroded. So I think this conversation could be titled Blurring Boundaries or Erosions. And it's nice to have this little narrative framing the discussion. I just want to push you a bit further on what you were saying about corporate separateness. And it's true that in antitrust, we've been seeing this for decades, that the law disregards separate legal personalities in assigning antitrust liability and often holds parent and subsidiaries liable for each other's conduct. You have a recent working paper in which you talk about how corporate law itself is moving towards a phenomenon that you called entity transparency. Can you tell us a bit what you mean by that and how it looks like in practice and what corporate law does in that respect? Because I'm sure that most antitrust lawyers who are listening to us are not aware that such a phenomenon of looking beyond legal personality is happening also in corporate law, and we are not the only special ones that disregard legal formalities.
Great. So let me go on to explain that particular concept. And that line of works, let me just say that it draws a certain distinction that I think is helpful for us to see what's going on. And that is the distinction between what is called in the line economics literature asset partitioning, which is the separation between the assets of the corporation and those of shareholders, and regulatory partitioning, meaning the separation between the corporation and shareholders for purposes of the imputation of other rights and duties that have nothing to do with making shareholders liable for corporate obligations. Because I think that conflation has impeded the appreciation of the dramatic forms of overcoming corporate separateness through veil peaking as an exception to regulatory partitioning. So in corporate, when I think about corporate separateness in corporate law, I'm not talking about making shareholders liable for corporate obligations. By the way, a shareholder corporate law is not in the business of making shareholders liable. It's in the business of providing rules for the governance structure of corporations and of implementing shareholder rights. So the types of questions that I ask is in the context of corporate group, which by the way is not exceptional. Corporations are large corporations are structured as corporate groups. Do some rules of shareholder protection apply only in connection to the parent company in which shareholders hold shares, or do they also cover subsidiaries? Some of those examples are quite traditional and are completely normalized, such as consolidated accounting. So you present the accounts of the group as a whole without much concern about the boundaries of the different entities in the group. But more recent developments have been observed with respect to other governance rules, such as derivative suits. Right now, the Brazilian government is debating a bill on private enforcement in corporate law, and so he's like, please pay attention to corporate separateness in the connection of derivative suits. So what if wrongdoing takes place at the subsidiary level? Can a shareholder of the parent company sue subsidiary directors? The answer increasingly around the world is yes. Can shareholders of a parent company inspect the books and records of subsidiaries? Brazilian courts initially said no. Delaware courts initially said no, unless you show something egregious leading to veil piercing. Now, through a statutory change in Delaware and through the evolution of judicial precedents in Brazil, yes, shareholders of the parent can inspect books and records of the subsidiary. You can also have the discussion in connection with approval of asset sales by a subsidiary. And even like in a number of contexts, the question is, do corporate laws pass through? And the answer that I'm giving, looking at what goes on instead of sticking with a certain abstract conception, is that yes, you do. That hasn't been conceptualized, but really the view of complete insulation does not describe the corporate laws that we have in practice.
So would you argue that we are
just before, because you said something that is really dear to me. I think we really have a great connection. And you mentioned something about the topics of boundaries, and that you see we were talking about disciplinary boundaries. We're talking about legal person boundaries. And there's just one more that I wanted to raise, because I'm even sometimes thinking about a paper about the problematic boundaries of law and economics, which I think affect both corporate law and antitrust law and so on and so forth. And one type of boundary that exists in it's kind of the opposite, right, from the other boundaries. This boundary exists in the real world, but is ignored by law and economics literature, is geographical or geopolitical boundaries. Mm-hmm. So I think this is something that I've studied in the context of corporate law, the role of nationalism in corporate law. That is also a theme that appears when you think about corporate law in the global south. Certain rules have different welfare or distribution implications if you look at results in the north and in the south. So I think there's this other boundary that's very much in my mind, and I think it's relevant both for corporate law and antitrust law, is how you think about the boundaries of the relevant space for the welfare calculus in each field, especially if the global north or global south are not necessarily best served by the same set of rules.
I fully agree with this view of law and economics as being a very abstract, borderless space, which is perhaps even hygienic, as in it doesn't take into account any concerns which are not purely economic. But as you said, nationalism and national interest can sometimes play a role because different jurisdictions have different concerns based on their inequality patterns and so on. Now, to keep the theme of boundaries, I want to bring in another strand of your scholarship, which I think is the most recent one, where you talk about actual blood ties between people. And I'm not going to bring into the discussion your daughters again that you mentioned before, but how family ties play a role in corporate separateness, and to what extent antitrust courts have started to look into family ties when identifying the boundaries of different legal entities.
Great. Thanks for that question, which really reflects quite recent work and also work specifically on antitrust law, but that has been inspired by this discussion that I mentioned before about separateness of legal persons, and what I think is a strong and often understudied analogy or parallel between the separate of natural persons. So I won't mention my daughters, and they have no implication for antitrust laws. And that, by the way, that line of work also relates to global south, global north comparisons, and not so much by design, but by outcome. It turns out that this type of issue has been more common in antitrust authorities in the global south, perhaps given the prevalence of family capitalism in the global south and its particular institutional manifestations. So the question here is, how will antitrust law react to family ties as circumstances that makes the boundaries between natural persons of the same family more porous? And antitrust authorities of various jurisdictions in the South have encountered this issue. For instance, one very prominent case occurred in Brazil in connection with the acquisition of JBJ of of a new meat processing company. The issue did not concern JBJ or the acquired company. If taken in isolation, they would pass muster under antitrust law rules, but it turned out that the siblings of the controller of JBJ were the controlling shareholders of JBS, which is Brazil's and one of the world's largest meat companies. And the question was, should we take those family ties into account in assessing the merger? And the Brazilian Antitrust Authority said yes. Ultimately, the judiciary said not so fast, and there was a settlement. Oh, which, by the way, the settlement included, as part of the remedies, some corporate governance remedies. And that is an interesting connection, quite popular in the Brazilian context between antitrust law and corporate law. And by the way, I'm quite skeptical of those remedies. But that type of fact pattern is not unique to Brazil. So antitrust authorities in Argentina have taken into account family ties in order to determine the threshold for purposes of antitrust notification. The same is true in Turkey. There's also the issue of family ties in connection with agreements in restraint of trade. So the Brazilian Antitrust Authority has various cases in which it takes into account family ties to find evidence of cartels or bid rigging. There's one case in Turkey, which was quite unique, in which the authority took into account family ties to find a form of single enterprise defense to a charge of horizontal restraints based on those family ties. But basically, the pattern that I find is that beyond the issues of ties between legal persons, there is this very important issue for antitrust law, which has been quite salient in the South, which is family ties as an instrument of economic coordination that then deserves the attention of antitrust authorities. And that is precisely what we have seen. So we have seen authorities that are sensitive to those dynamics and that have adapted antitrust laws to account for those dynamics.
I think this is a fascinating dynamic because it shows that what the law perceives as completely separate legal entities are actually connected by social ties, which as lawyers we tend to ignore because, especially if we live in a law and economics kind of environment, we don't think about how actual real world situations look like and how the boundaries that we tend to create as lawyers might be surpassed by the messy realities that we live in. Now, the hour is almost over, which I'm not surprised because that's always the case when talking to you. But before ending the conversation, I want to ask you two questions, which are perhaps a bit more personal. The first one is, how did you get interested in antitrust issues? How did they come to inform your scholarship? And the second one, and this is mainly for the benefit of our listeners, whom I'm sure have just discovered how much they can learn from corporate lawyers. What would you recommend them as a starting point if they wanted to understand more of the corporate law dynamics and how they could impact antitrust? And of course, I recommend everyone to read all of your scholarship because reading it has taught me more about antitrust than most antitrust scholarship.
Well, thanks, Teodora. So the way I got interested in antitrust is that I came across it while looking at the corporate law issue. So so in that the paper, the earlier article that we mentioned with Henry Hansman on voting caps, there was a huge debate about the reason for voting caps in the 19th century in various countries, including Brazil. And we thought that the explanation in the literature that was a form of investor protection was not sensitive to what was going on. So we were eager to adopt an alternative explanation, which we thought fit the data better, but was bold in that way in abandoning the standard explanation for corporate governance practices. So in that case, it was by chance. In the case of corporate separateness, I think clearly antitrust, when I began thinking about corporate separateness and other areas of law, I think I'm interested in looking at legal rules also from an interdisciplinary perspective. Part of what inspired my work on corporate separateness was the line of works on, there's this book, We the Corporations, on how the U.S. Supreme Court treated corporate separateness in the constitutional law context, and therefore I began collecting examples from various fields. So I came across antitrust law there, and then because of corporate separateness, I began having an interest in legal separateness with respect to natural persons, and I noticed examples in corporate law and in other areas of law. So in that particular case, and I think this is very important to know, we learn a lot from our students. I learned a lot from that conversation I had with you. And also I had this student who liked the concept of veil peaking. She was interested in antitrust law, and she proposed a project of scientific initiation, which is something, type of research project that undergraduate students do. And she wanted to study veil peaking in Brazilian antitrust law, and the hard questions, right? Because some of it is quite trivial, but we stumbled in the problem of family ties, and then I thought, well, but this is so fascinating. Why don't we go with family ties instead? And that's how I ended up reaching this antitrust law in that. In the letter account. In terms of how do you learn is that the question? How do you learn corporate law? Well, I would highly recommend The Anatomy of Corporate Law. I think it's a very straightforward introduction. One of our goals as authors of the 3rd edition was to make it shorter than the 2nd edition, which was extremely hard, but we succeeded. The only caution, again, it would be to reach that literature with an open mind, because I think sometimes the narrow lenses currently shaping the literature perhaps impede broader insights. But that's basically my 2 cents on those issues.
Thank you very much, Teodora and Mariana. I think unfortunately I have to end, and I'm going to pass the word to Eduardo.
Hello, Mariana and Teodora, nice to see you in this panel. I just jumped in to say how delighted we have, in the name of the IBCI, to have you, Mariana, with us again, and congratulate you for your brilliant career. And I must say that I always learn with your words about corporate and etc., not only corporate law, but it's looking at the world from the corporate lens. So that's pretty much fantastic on my end. Thank you very much. Thank you, Teodora, for this brilliant idea to invite Mariana to be with us. I hope we can keep this discussion soon, right? Unfortunately, we have a short time now to start another panel, but I congratulate you to Teodora and Mariana for the lessons, for the brilliant discussions, and Vinicius again, thank you very much.
Thank you. It's been a pleasure.
Thanks, Eduardo. But next time I'll interview Teodora, because I'm really curious. Now we ran out of time, and I still don't know what she's up to, and I know
right.
I'm inspired by that. And
thank you very much for accepting in a so short time. We appreciate it a lot, Mariana. Thank you very much.
Thank you, everyone.
Thank you.